We're talking about contracts today, and I want to begin by just explaining the difference between a promise and a contract. The difference is that a contract, you can go to court and get it enforced, but a promise, you can't. And there are certain requirements that have to be met for a contract, and we'll look at each of those in turn today. Why are contracts important? Well, they help provide some stability in the business relationship, and maybe the most important thing about contracts is that they're useful for assigning risk. So if something goes wrong, the parties will know who's responsible, who bears the risk in a particular situation. In the United States, we have something called freedom of contract, and basically that means that you're free to agree to whatever kind of deal you want to agree to. And so if you agree to a terrible deal, well, tough cookies, that was your choice to do so. What law governs in the area of contracts? There are two categories of law that can come into play here. First, there's the common law of contracts, which, if you remember from previous chapters, the common law is those legal principles that have developed over time, judge-made law. Well, the common law of contracts is going to govern in areas of real estate and service contracts. So if you're buying or selling a home, or you're hiring someone to mow your lawn, or something like that, repair your car, then the common law of contracts is going to govern. The other area of law that comes into play is the Uniform Commercial Code. And those are statutes that come into play when we're talking about contracts for the sale or lease of goods. And we'll talk about that in a week or two. But today our focus is going to be on these common law contract principles. Now, when you're forming a contract, there are four requirements that you have to have. First, you have to have agreement, which is an offer plus acceptance. Second, you have to have consideration, something of value that changes hands. Third, you have to have capacity, meaning that the parties understand what they're agreeing to. And fourth, the contract has to be for a legal purpose. So let's begin by talking about agreement. Agreement is an offer plus an acceptance, and the person making the offer is referred to as the offeror. The person with the power to accept the offer is referred to as the offeree. So when we're making an offer, there are three requirements that have to be met. First, there has to be an intent to be bound. There has to be, second, definite terms. So we've got to understand who the parties are and what we're talking about in terms of the contract. And third, the offer has to be communicated to the offeree. If it's not communicated to the offeree, then the offer isn't complete, because the offeree doesn't have that power to accept if they don't know about it, if it hasn't been communicated to them. Now, when determining whether an offer has been made, a valid offer has been made, we apply this objective, reasonable person standard to make that determination. And so we may have to look at the facts surrounding the situation to determine whether there really was an intent to be bound, whether the offer really was communicated. And one case that really illustrates that very well is the case of Lucy versus Zimmer, and that is in your textbook. I would encourage you to take a look at that and look at it in terms of an objective, reasonable person, and try to determine, was there an intent to be bound, and was the offer really communicated in that particular case. So, would these things be considered offers? Advertisements. As a matter of public policy, advertisements are not considered offers. They are rather considered an invitation to go and negotiate. You could imagine the problems we would run into if a store was obligated to make good on every advertisement that they make. If every customer came in there with the power to accept that offer, it could create some chaos. So as a matter of public policy, advertisements are not considered offers. What about these other three statements here? The expression of opinion. I think I'd sell my car for $5,000. Well, that doesn't sound like there's really an intent to be bound there. And then the statement of intention. I'd like to sell my car for $5,000. Well, there again, there's not a clear intent to be bound. And then the last option there, an invitation to negotiate. Would you give me $5,000 for my car? Well, we're getting a little closer to an offer. But again, there doesn't seem to be that clear intent to be bound, so I would say that each of those three statements is not a valid offer. Once an offer is made, how does it terminate? Well, it can terminate by the action of the parties. The offeror can revoke the offer, meaning they can take it back anytime prior to acceptance by the offeree. One exception to that is if it is an option contract, meaning the offeree has paid some money or given something of value in exchange for keeping that offer open for a set period of time. If that has occurred, then the offeror cannot revoke the offer until that agreed upon period of time has passed. The offer can also terminate if the offeree rejects the offer. Once it's rejected, that's it. The offer is off the table. An offer can also terminate if the offeree responds with a counter offer, meaning I'm going to reject your offer, but how about this? And so that's common in the negotiation process. They may reject an offer and come back with a new offer, a counter offer. An offer might also terminate by operation of law. The general rule is that an offer remains open for a reasonable period of time. What's a reasonable period of time? Well, it kind of depends on the circumstances, and that would be a case-by-case determination. An offer can also terminate if one of the parties dies or becomes insane, or if the subject matter of the offer is destroyed. For instance, if I offered to sell you my car and then before you accepted, my car exploded, well, it was destroyed, that would terminate the offer. And then if there's some new law or something that passes that causes the subject of the contract to be illegal, so a supervening illegality, that would also terminate the offer. Once an offer is made, like we said, the offeree has the power to accept. And there are some requirements related to acceptance. First, the acceptance has to be unequivocal, meaning that the offeree cannot change anything about the offer. If they do, then they've made a counter offer, right? So this is called the mirror image rule. The acceptance has to match up exactly with the offer. The acceptance also has to be communicated to the offeror. Silence is usually not enough to constitute acceptance. Unless, if it's an implied in fact contract, then acceptance will be determined based on your behavior, and silence may be sufficient there. It might also be sufficient if you've had prior dealings with this offeror and maybe you have a set order that you make every month or something like that, and based on those prior dealings and prior acceptances, silence may be sufficient. But other than those two situations, silence is usually not enough to communicate acceptance. Acceptance has to be timely made. Remember, that offer is only going to be open for a reasonable period of time. Also, the offeror is considered the master of the offer, and so he or she can place specific limitations on the offer and say you have to accept within X number of days, otherwise the offer's off the table. So if that's the case, you've got to make sure that your acceptance is communicated within that time frame. There's also something that comes into play with acceptance called the mailbox rule. And basically, the idea here is that an acceptance is going to be effective the moment that it is sent, but a rejection is only going to be effective when it's received. Why would we want the acceptance to be effective the moment it's sent, but the rejection is not effective until it's actually received by the offeror? I think this goes back to encouraging business and encouraging deal making, and so we're going to let that acceptance be effective the moment that it is sent. If you have a unilateral contract, those types of contracts can only be accepted, or acceptance can only be communicated by performance. All right, now a few words about consideration. Consideration requires something of legal value being given in return for a promise or act, and there has to be some bargained for exchange, meaning that each party should be getting something or giving something up. Usually consideration is going to be money or goods, something like that is changing hands, but it can also be an act or a promise to act. That would be true in service contracts, or it could be forbearance, agreeing to give up doing something that you have a right to do, or a promise to give up something that you would otherwise have a right to do. Now, some things do not constitute consideration. One such thing is a pre-existing duty. If it's something that you already have an obligation to complete, then that is not sufficient consideration for a new contract. An example of that, maybe you would offer to pay a police officer $100 if he would drive past your house each night and make sure that things are safe. Well, as a police officer, he already has a pre-existing duty to do that and to make sure that things are safe, and so that would not be valid consideration and would not be a valid contract. Past actions do not constitute consideration, so consideration has to be something that is, in the present or in the future. And lastly, moral obligations or gifts do not constitute consideration as well. There's sort of an idea out there that consideration has to be adequate. Now, courts are not going to undo an unwise contract. Remember, we have that freedom of contracts. But in extreme cases, if there's inadequate consideration, it may indicate that there is fraud or duress or undue influence involved in the transaction. So that may be something that a court would look at in those situations. And the last thing to mention here under consideration is the idea of promissory estoppel. And promissory estoppel is an equitable doctrine that a court will apply really just out of fairness. The court will find a promise binding even though there is no consideration, if that's the only way to avoid an injustice. One area where courts have done this is with pledges to nonprofits. So maybe you pledge a large donation to your college for a building campaign, and they rely on that promise and line up the contractors and start construction, and then you take back your promise and say, no, I'm really not going to give you that money. Well, that's not fair to the institution, right? And so the only way to avoid that injustice would be to go ahead and enforce the promise as if it were a valid contract. And so a court could do that through promissory estoppel. All right, so that's a quick overview of offer, acceptance, and consideration. And in the next presentation, we'll talk about capacity and legality.